For those of you who haven't turned, okay, so now you're going to see a big box has come up that says recording in progress. Just hit got it, unless you want to leave the meeting. I don't think you do. If you can just turn your mics off so we don't have any feedback, that would be helpful. There are still a few people coming in, so I'm going to repeat this at the end of my presentation, but there you go. So welcome. I'm really, really excited for today's discussion. This has come from a few discussions we've had with people and different events. And fundamentally, we're going to focus on different issues around family law. It was driven by conversations I've had with people and asking about their rights to access to grandchildren. Specifically, in some situations, if they're going through, for example, if their daughter's going through a nasty divorce and she's having difficulty accessing the grandchildren because there's animosity between the couple, where does that leave the grandparents? But we're also going to look at some bigger picture issues around family law. Because Quebec is quite particular and our laws are different than the rest of North America, there's a lot of things that people don't necessarily know. There are a lot of assumptions that are made that we operate in Quebec the same way as the rest of Canada. And even though we should all know by now that that is not the case, we're going to review some of the specifics so that you understand what your rights are and what they aren't. I also just want to say a quick thank you to Ruth Pelletier, as usual, who did a wonderful job organizing this for us, as she always does. She has also been instrumental in putting together our next two events, one in early November, November 9th, on tenants' rights and responsibilities. This will look at different issues around leases. And I recommend that you tune in for that, because this is something that people find themselves struggling with at times, whether they expect to or not. And then in December 7th, what I call our optimistic webinar, and that's on traveling during a pandemic, insurance, rights. Are you protected? Are you not? How are you protected? Because it's very particular. And so I like to think that at some point we will be able to travel. And so it's important that you understand what you're covered for, what you aren't, what are the risks you're facing if you choose to travel this early in the pandemic. I'm going to call it the pandemic recovery because I'm an optimist. So I am now going to turn this over to our wonderful guest, and I'm really excited to have Linda here. When Ruth first told me who was going to be presenting, the name kept ringing a bell. And I was like, I know who this woman, how do I know this woman? And she's actually done a lot of work on a cause that is very dear to my heart as a dog owner. Linda is a lawyer who has a really interesting array of expertise. I'm going to read you her bio and you will see. The cause that I followed and why her name is familiar to me is I'm a dog owner and I have pit bulls. And so a few years ago, as you know, in Montreal, there was all the kerfuffle about breed bans, and Linda was at the forefront of encouraging that we discuss breeds based on science and not on fear, and did a lot of excellent work in that area. However, she has worked in many other fields. So I'm going to go over her incredibly impressive bio and then turn this webinar over to her. Linda was a graduate of Sacred Heart High School, where she later was appointed to the board of directors and a trustee. She went to Loyola CJAD and then went to France to study for a year. Went to University of Montreal and obtained 2 degrees, one in political science, the other in law. And then early in her career, between 1982 and 1992, she worked at 2 different firms and then started her own firm, which is where she's still working today. She's a co-founder and the secretary at the Association of Family Lawyers of Quebec. She has appealed cases in the Superior, Supreme, and the Court of Appeals. She is one of the, among the first group of family mediators in Montreal, and has been involved in various groups with different expertise, child abuse prevention, Velvet Hearts contesting the breed ban brought in by Mayor Denis Coderre. Don't vote for Coderre. She's a board member for the Lake Hughes Association from 2008 to 2019, and a board member for the Bar of Montreal for many years. Also very well known in different media outlets. She was a guest for Dr. Laura Betito. I remember this show, The Passion Show with Dr. Laura Betito on CJAD from 2013 to 2020. And then has also worked with different other media experts, has been invited as an expert on different other medias such as CTV, Global, and was a voice on an NFB animated short film. I could read through the rest of this. The other important thing is her special interest is dogs. So thank you so much to Linda for joining us to discuss some of the different issues around family law we're going to talk about today. Linda, I'm going to turn it over to you. Thank you.
Well, thank you very much. And thank you to also Ruth and, excuse me, Katsia for helping organize this informative, hopefully, conference that we're having. I just lost all your pictures. I don't know if everybody wants to at least turn their videos on. So there you are. At least I have somebody to look at.
I'll leave mine on so you're not staring. I know what it's like when you're just staring at a black screen.
I'm talking to the wall here,
yeah.
Except it's black. I don't paint my walls black. Good. So I want to say good morning and welcome first to everybody who has taken the time out of their morning to listen to me ramble on about my passion and career as family law. And I understand there may or may not be a few men in the audience, so welcome to you too, although I gather that it's predominantly women, and that's fine. And just to point out, when Vanessa said that about the grandparents' rights or whatever, in case their daughters are having difficult divorce, sons have difficult divorces too. Let's make that clear, so it works both ways. Anything I'm going to say usually works both ways for both sexes. And who knows? Oh, you forgot to mention, I also used to do wedding shows. That's in there. I had 5 kiosks at various wedding shows over the years. Sheldon Kagan's one, and I did an LGBTQ one, and et cetera, like this. And that sort of, in a way, gets me to the first question that I'm asking all of the listeners. And if you chat the answer to Vanessa, will read it when I give her the cue as to what are some of the answers. What the first question is what is the first cause of divorce? Simple question, not necessarily simple answer. All right. You also have to realize that in 40 minutes, 2 breaks, I think of 20, I'm not going to be able to cover something that I've been involved in for 40 years. So this is going to be a very broad overlay of some points of interest that might interest the listeners. In any facet of life, there are 3 types of information, then maybe even 4, of which Vanessa touched on before. First of all, there's what you know about any given topic. Secondly, there's what you know that you don't know. So some people actually know that they don't know something, and ergo they try to find out information on that. Third would be what you know that you don't know. So, you don't necessarily know a certain aspect of what happens when a spouse or partner leaves the house, but you don't even know that you don't know that. So it makes it very difficult to ask questions to get the answers if you don't know that you have an issue that you need dealing with. And then, of course, also there's what you think you know, which turns out sometimes to be completely wrong. The biggest one in Quebec, as far as I'm concerned, I've harped on it for decades on the radio, is that there is no such thing, write this down in big letters, as common law in the province of Quebec. Doesn't exist. That's all the rest of Canada, maybe the United States, lots of other places, not in Quebec. We are governed solely by the Quebec Civil Code, in which there is no common law. And the Divorce Act, and again, which there is really no common law, although they touch on it when they have to deal with every other province's matrimonial issues. Probably the reason for this misconception is that there are such laws, such as the revenue departments of Canada and Quebec, that allow people to deduct what they consider to be They may say it even on a form, a common law partner, or how pensions are governed by your employer, and they refer to common law. It's just because people do that, but legally, it doesn't exist as far as we're concerned in the civil code. And any foray into family law, I've lost you, by the way, Vanessa, your face. There you go.
Really?
Yeah, there you are. Now you're back.
Okay.
You were gone. Okay. Is to find out information and know the questions that you should at least try to ask. And this requires seeking oftentimes legal advice from one area or another. This morning is one of those issues. But before I get to asking about that, I'm curious to know if anybody took the time to answer my first question about what's
Yeah,
the
we
first
had a few answers, Linda. The majority of people say money is the number one reason, and then lack of communication or mistrust are the other suggested causes.
Okay, those are ancillary to the first cause of divorce, and that's marriage. Because you cannot get divorced unless you are married, which is why the court demands to see the marriage certificate, because they're going to waste their time divorcing people who aren't even legally married. And in order to get married, everybody, yourselves, your children, your grandchildren, need to know that they have to find out what is going on. And this was one of the key reasons why I did kiosks at wedding shows. And believe me, I got a lot of stares from people who'd walk by, and invariably it was the parents of the newlyweds to be that would drag them back to my kiosk to take a pamphlet or a business card, because 50-50, you're coming to see somebody like me down the road. And yet this entire type of venue is accented towards the type of font on the wedding invitation, the color of the napkins and the tablecloth, and where you're going for a honeymoon, and all those kind of details, and the place settings and the food and whatever. How about how it is that you're actually going to interact when you're living together? And this can apply also to people who aren't even bothering to get married, they just live together. You need to know and have regular conversations with your beloved until what I call is the underwear stinks. Because, everybody, the young girls, when you were young girls, I'm sure you all had relationships where you'd smell his cologne or her perfume or whatever, and you'd go home and something would linger and oh, I love this person. It's just wonderful. And 10, 20, 30 years down the road, pick up your damned underwear. It stinks here in the living room. And but unfortunately, by the time you get to that stage, it can be often too late to have a calm and amicable discussion about what should happen. It needs to take place before you start to move in with people or get married. You need to talk about finances. You need to talk about what you're going to do when you have children, what kind of schools you foresee, them attending, what kind of religion you're going to raise them in, what kind of house you want to live in, who's going to pay for it, how are we going to run the bank accounts, et cetera, et cetera, et cetera. And not just once. You need to have this conversation, sort of like the Russian 5-year plan at least. You need to sit down and reevaluate, just like you would do with a stock portfolio. You just don't buy a stock and then wait 50 years and hope something good happened to it. You need to treat it like food on a stove. If you don't stir it, eventually it's just going to steam out, burn, and disappear. So you need to take care of yourselves and know these things. Now, getting back to the answers that you gave me for question 1 before, once you're married or living together, a lot of the animosity that becomes created is from not dealing with issues as they arise, or staying silent because you think that's going to help with keeping the relationship going. And invariably, it's going to be the financial issues and or the children. Those are basically the major two. Everything fits into those two categories if you have children. And if you don't have children, it's all about finances. And sometimes sex, but then you can turn into Dr. Lori's podcast because she's still doing that. So you need to know the details. How do you know the details? A lot of people glaze over the minute the dollar sign comes out as to what's in the mortgage deed, how are we going to do the bank account, who's going to pay the hydro bill, etc. But these are integral parts of everyday life, and you can't abdicate this to the other person. A lot of time, and it doesn't have to only be women that do this abdication, men too. Oh, she takes care of all the finances, and I don't know. Well, when you're going to end up going to have to see a lawyer, the lawyer's going to ask you all these questions. So why not have the answers in advance? And you may not even need to go to see a lawyer if you have all these answers in advance, because you'll be part of, it's like putting on your underwear in the morning, for all of those of you who wear underwear. Anyway, so you have to work on it. It's a job being married or living together, even though you don't want to necessarily contemplate it that way at the get-go. So first rule really is never sign a document of any kind unless you actually understand. Just because the other one comes home, opens the briefcase and says, here, sign this, they need it at the bank. That's nice, because either you're putting yourself on a joint line of credit, or you're, I don't know, taking your name off of a bank account or whatever. And if any of that applies or whatever, ask, well, why? Why do I need to do that? I have to think about it. It's no rush. Things should never get to a point where you have to rush to sign a document that's a financial consequence for the rest of your life. When you're more than entitled to get the advice during the time, even if you're married. Doesn't mean that you don't trust your partner, your spouse, just means that you're smart. So this brings me to my second question. You're joint owners with your partner or spouse of a property, and it's 50-50 in both names. Either during the purchase of it or after the purchase of it, one of you puts in, let's say, an extra $100,000 into the purchase. You took it out of your savings, you borrowed it from your parents, whatever, you earned it during the time, you saved it and you contributed to it. So the question is, if you're going to have a split, what are you entitled to get? Are you going to get this extra $100,000 automatically back before you would, sell the house or whatever property we're talking about and split that because you're a co-owner? So that's a question which I don't need the answer to immediately. Talking about what you need to know about whatever, you need to know the numbers. So you need to keep a copy of things that you sign. You just don't sign and leave it. I've heard people, they sign deeds. I have a client right now. Can you bring me the deed of the house? Well, I don't know. The notary has it. Well, that could be 30 years ago and the notary's dead. It makes it a little difficult to get copies of deeds. Where did his files go? So on and so forth. Whatever you sign, keep a copy. Yes, keep a copy, scan a copy, do whatever you need to do, but keep a copy so that you have and organize it however you want to organize it in files. Just don't throw papers in a pile and 20 years later try to sort through it. And you'll be at your fingertips and easier to deal with should you need it for any reason, not just for a divorce. And in order to maintain a healthy marriage, this is like a prime rule that you need to follow. Even though our Supreme Court in Ottawa has ruled in cases that marriage and or partnership is not necessarily a financial exercise and you have to keep ledger books of finances and all this, that's lovely in theory, but the fact is that when you're in a courtroom in front of a judge and you want to get divorced and you want to claim X, Y, or Z, you're going to need numbers. So, it's not just, well, I think that in 1973, I put $5,000 down, but I don't remember where or how or from whom or what is. It's called evidence, and the best evidence is usually the one that carries the day. And if your thoughts about what you might know, but if you have a little folder, it says, here's a copy of the $5,000 check. I got it here. Here's a little note from my mother and father that said it's a loan, not a gift, to me alone, and that would be the subject of an entirely separate conference. Bills, renovations, bills, checks, some people also, they love to pay cash, but of course they have no proof that they put all this money in. I've never understood that, because I believe in one, getting a bill and paying for it on Visa or by a check or whatever, because if something happens to that reno, at least you have proof that you can sue the guy that screwed up your house and the leaking windows that you now have. So there's many reasons besides for an eventual divorce to keep all these things. And how much of the house expenses? So I'm going to be sending Ruth a blank spousal budget. Don't think of it as a spousal budget for divorce necessarily, but as a day-to-day planner for every category that you would have to do anyway if you were getting a splitting up or getting a divorce. And it'd be interesting to see how, when you add up the second and half of the third page, what your monthly fees are and expenses, and then the talk. So how are we going to, divide this, dear? The code says that the couples contribute proportionally to their incomes. So if somebody's earning 0 and the other one's paying 100%, that person can't come back later and say, I paid for everything and I want money back. Doesn't work that way. First of all, the longer the marriage goes that the person is paying all the expenses, it's tacitly assumed that they agreed to do that. So if you don't agree to it, another client I have for the 6 and 7 years of the marriage, get a job, never got a job. And now they've been separated 7 years, still doesn't have a job until just last year. But, the rule basically, when you go into a courtroom, you don't get an immediate divorce. So there's provisional, and provisional courts like to maintain the status quo. So if somebody's been paying for somebody for 13 years and now longer he's been paying than for the marriage, it's the duration of the marriage, it's going to continue to go on. So if you really want somebody to get a job and they're not getting a job, then you should be going to a lawyer and getting out of the marriage. You can still live together and sin if you want, but it doesn't matter. You can at least put your foot down as to what you want. The same thing applies if you're the wife or the girlfriend and you're working and he's sitting at home, I don't know, playing Gamblers Anonymous. You need to put your foot down for certain things. Otherwise, you're deemed to have accepted the disaster and you can't come back and complain about it 20 years later. Another interesting thing about expenses and experience and examples are the best to understand. I had a recent case where the couple was joint owners of the family domicile. Divorce proceedings were taken, and subsequently the entire house burned down. But the insurance was only in the husband's name, and because he was a so-and-so, I won't use the words that really should be describing this particular person. I don't hate men, by the way, any of you are listening. I hate people who are assholes, be it women or men. And so he refused to allow the wife, through his lawyer, to have, a copy of the insurance policy. She's a 50% co-owner of the property. Why she let him only be on the policy is another issue, which is why you need to sit down and talk about these. And then he made the claim for the damages from the fire, and he won't let the company send us a copy of the claim to see what it is exactly he's claiming or what the insurance company is doing. And then, of course, you subpoena this information and they get their big lawyers to come and tell you, no, you got to go to court, get a court order. And it's all costs the lady who didn't take care of herself in the first place money, which, can be oftentimes not available. All right, back to you, Vanessa. What's the answer to question 2?
My mouth is still on the floor from that poor woman whose house burned down. I mean, talk about a cautionary tale.
Yeah, well, I have 40 years worth of those. So
yeah. Okay, so 50% of the profit made plus any extra.
No, not a profit. They just own the property.
Okay.
Oh, this is your answer. You're reading an answer.
Right. So if someone has sold it, let's say you sell it, you would split 50% of the profit plus get back whatever extra you put in. I think is
no.
No.
Well, the answer would be no.
Yeah.
What do you want to say?
I think it's whatever you choose to put in, the property remains 50-50. Because that's what.
Unless You had the foresight in either the cohabitation contract that you have because you're not married, you're just living together and bought a property, or in your marriage contract, or no, sorry, not in the marriage contract, in the deed of sale or deed of purchase. When you first got it and you gave 100 and the other person gave 50, you say, I'm going to get 50 back. Okay. Regardless of whatever happens, but it's got to be in the deed because a notarial deed is the best form of evidence, as well as keeping those checks. So unless you specify it concretely, you're presumed to have wanted to make a gift of that extra 50,000 to the other spouse. Otherwise, why would you do that? Oh, I love you dearly, yes, but they're going to hate each other down the road, especially when they don't want to fork over that other 50 grand. So that's that. So,
or the insurance money if your house burns down. Good God, I'm traumatized now.
But nonetheless,
I'm running to check all my insurance papers the second we're done.
Got to read everything, and things change. So again, just like that, you need to update the insurance company usually sends you a little paper that says update to see if it still meets your needs. Well, same thing with the couple, for God's sakes. Anyway, and about that, just because the insurance may cover the house for let's say $500,000 and you put in 100 and the other one put in 50 and it's a 50-50 ownership, the insurance company isn't going to give a darn about who put in more. They're going to say, here's the check and figure it out yourselves. And if that's in the middle of a divorce, it's going to be an issue. So you're either going to have to seize the money, more legal fees. It's not like I don't like making money over the years, but I don't like having to deal with stupid issues that should have been resolved and never occurred in the first place. So there you go. Don't mind me, folks, because I get in a rampage about all this stuff because I say it, but saying it for 30 years and radios and TVs and whatever. Nonetheless, I had a client come in. She was in her early mid-20s. And I said, well, whatever, can you look up the check? They went, oh, I'm not allowed to have a checkbook. Almost fell off the stool at the conference table. What do you mean you're not allowed to have a checkbook? I can't write checks. He controls all the money. Can happen in reverse. It's like, what person this day and age reads any form of content on the internet, the TV, on the hair, something in the newspaper, and not know that you have to deal with these issues and that you're allowed to have a checkbook? But that's, a whole other kettle of fish. Okay. Question 3. Before I continue, and again, a married couple or a non-married couple who own the house jointly, as in the last example, and one of them files for divorce or separation or some other procedure for non-married people and requests the exclusive permission to reside in the house, which is granted. Who pays the expenses at that point in time until there's a settlement or a court judgment? That's question 3. Aren't these exciting? All right, so you probably all heard, well, maybe some haven't paid a lot of attention, some it might not apply to anymore, or whatever. Family patrimony. Family patrimony was brought in 1989, and for anybody that was married at the time that was brought in, you had 18 months to opt out of it by notarial deed, failing which you're stuck with all the terms and conditions of the civil code governing the family patrimony, which, by the way, is what we call public order, which means that you cannot contract out of family patrimony, except for that one specific example, after the fact. You can't get married and buy a house and then make a little contract or even go to a notary or a lawyer and try to contract and say, the house won't be part of the family patrimony. No, that's illegal and not valid. So you have another reason why to decide how you're going to deal with the family patrimony. There are 5 categories of assets in the family patrimony. The immovable property, the house, usually country houses. Sometimes judgments have included, boats. I'm not talking about the dinghy at the dock. I'm talking about a yacht, or something substantial that you've, vacationed on, and it's sort of like a residence. The condo in Florida, all these things are part of the first group. And basically, the premise is that everything is 50-50, but there are numerous examples of how that's not in fact the case. If the property that you reside in was pre-owned by one of the spouses and paid for completely, it's excluded. If it's not paid for completely and there's some mortgage left and then that's partially paid or paid off during the marriage, there's another mathematical collection. Remember, the Supreme Court says marriage isn't math. That's BS. Anyway, so you have to remember that. Second category are. What happened?
Sorry, can someone, whoever it is who's on their iPhone and has forgotten to mute themselves, can you please all make sure you're on mute? Thank you.
Okay, so the second, not in any specific order, second category is the furniture that garnishes all those movable properties that was in the first category. And depending on, even if you brought it in, it can be lumped together with what you bought during the marriage, but then you can ask for an exclusion, although after 30 years, do you really need to have, unless it was great antiques or a Rembrandt that you want to have it back, or anything like that. Cars, the family cars, not the car that somebody owns and never lets the other family in, although there are arguments. You have to understand, you can argue about anything in a courtroom. Even if you're wrong, one side can decide, especially if they have more money, to try to intimidate you into submission by arguing over everything, like the insurance policy example I gave you, which, if you get in front of a normal judge, they're going to, grant it, but the cost to get there for something that shouldn't have taken place in the first place is ridiculous. RSPs and pension plans are also part of the family patrimony, and that also includes the Régime de Rente Québec. In a divorce settlement or a judgment, one side can ask for an exclusion due to numerous reasons, including either a short-term marriage, or it's not fair, or let's say somebody contributed to their RSP diligently and the other person didn't make a dime, and so you have $100,000 in your RSP, of which $50,000 now goes to the other side, but they did nothing and they gambled away money, and etc. You can ask a judge to deduct that asset from the partition. I always tell specifically men who theoretically always have more money usually, that if you want to, have a good time with the RSPs, make spousal RSPs for the wife. You put your money in, you're going to get your tax deduction. 10 years down the road, you're going to get 50% of your money back that you already had a tax deduction for because of the family patrimony. So, that works as a good financial plan, for the person who's paying that. Then I think I covered the furniture there. I'm missing something. No. Oh, the Régime de Rente Québec I consider to be a fifth thing. Now, some of the exclusions or deductions that one can take is if some of that property, and it has to be that property, not something else, not money necessarily, unless it was put into a family patrimony asset, if it was a gift from your parents, or if you inherited it from Aunt Matilda, and you have keep the copy of the will, keep the adjustment sheet to be able to prove that you had a gift or a succession, inheritance, whatever, and that can be deducted most of the time. There are 3 other matrimonial regimes in Quebec, according to the Civil Code, one of which is next to non-existent anymore, because before 1970, what was called community of property. There's next to nobody that's getting divorced who were married before 1970 that would have to deal with this. And it was a horrible regime in the first place, so complicated, it's ridiculous. Either the people who got married back then are either, God forbid, dead or already divorced. So, and when everybody was ever married before 1970 who didn't have a marriage contract saying they were separatist of property, we'll have to deal with that. As time goes on, it'll be less and less. Then the Quebec government brought in what's called partnership of bequests. That was trying to make a level the playing field as opposed to the separationist property, so that everything is basically accrued during the marriage is 50-50. Again, with many different ways to deduct certain things. And of course, there's the marriage contract, which I recommend everybody to get no matter what. I was on the television years and years and years ago about marriage contracts, and they juxtaposed what I was saying with, they went and, interviewed a couple of couples they stuck in there, and young couple, and, are you going to get a marriage contract? Well, we don't have anything. My question, my answer to people who say they don't have anything is, and are you planning to stay that way? Because if you're planning to not earn a dime, live with your parents, even though you're married, and buy nothing and do nothing, and whatever, you're going to accumulate assets, debts too, probably, but certainly you're going to accumulate assets. Particularly for people who are also have businesses, if you don't have a marriage contract, the business is going to fall in to the division down the road. So first you divide the family patrimony, because that overrides the other three. And then whatever's left that might exist, you divide that too, subject to whatever rules govern exclusions. So now it's time for answer 3 to my question about who pays for the expenses of the property.
Nobody was brave enough to venture a guess.
What?
Nobody was brave enough to venture a guess.
Oh, nobody's brave enough now. Okay. Well, the answer basically is multiple. A judgment of divorce, which, as I said before, takes a lot of time. There is what's called an interim period for urgent measures, which usually is who's going to stay in the house, because most people are getting divorced because they can't live together. Although there are some sane people who can, one lives in the basement and whatever, and they figure it out and it's more amicable, and that's okay. But basically, a court will rule either inside of the spousal budget that causes expenses to be listed and what everything costs, as to who's going to pay, if necessary, alimony, and which will include expenses of the house, or it can be in addition to the alimony payment. The alimony is deductible, the house expenses not necessarily, unless you're able to get a court order or make a consent on an interim basis that says that it's going to be a deductible expense like alimony. And that brings me to opening a parenthesis. Because there is no common law in Quebec, you are not entitled to alimony if you're not married, or unless you have a cohabitating contract that said that, if we get separated, I'm going to pay you $1,000 a month until whatever, or whatever number. So you need to figure that out if you separate. You're entitled to child support if you're not married, and sometimes certain expenses, but in general, don't think you're living with somebody for 20, 25 years and wake up one day and go, I'm not entitled to alimony? No, you're not entitled to alimony. Neither will your daughters or sons be entitled to alimony should the circumstances so warrant, because you're not married in this province. So that was the answer to number 3. So what are the kinds of claims, apart from just, getting divorced? People say, how long does it take to get divorced? In Canada, we have a Divorce Act, which was just amended in April for mostly due to conjugal violence, but and other things, and in which grandparents, by the way, have more rights now. But again, it's if your children are married, not if they're just living together. That's a whole other issue. So the claims can be, again, alimony. It can be child support. It can be lump sums, which is, let's say you're getting divorced and you've been driving the 1995 Volkswagen Beetle that's rusted to the floor and whatever like this, but you're the mother or father of the children and you need a car to transport. You can ask for an amount to be able to buy a car, because that's a necessity of life, usually speaking, and a court can look at that, obviously depending on the capacity of the other to pay. There's such thing as a provision for costs. You can ask for legal fees to be paid. You can ask. It's not a guarantee or a lock. And so you have to understand that your lawyer is not going to finance your bill unless you're eligible to legal aid, and then it'll be the government paying for you. So just because there's a request for it and a conclusion about it, unless a judge rules on it or your spouse agrees to pay you some amount of money, you're responsible for your own legal fees, which in the case of people asking for support, child or alimony for themselves, is usually deductible. It's a tax deduction on your income tax, not for the part that's about divorce itself, but for getting support from the other party. there's what we call a compensatory allowance. So that was brought in 1982. And the family patrimony was brought in after because they figured what the compensatory allowance was supposed to do wasn't yet being really done because of that. So they brought in the next rule, and every year in September, we're told at the bar when they open the courts, access to justice for everybody. The more forms they put in, the less access to justice there is, and the more it costs. And then they blame the lawyers, but it's the government, people, it's the government. So compensatory allowance, and of course, when it first started, even the courts, the judges, they didn't know exactly how to interpret it. So some people said, I've been dusting for 30 years and I'm entitled to $50,000 and they would get it. Well, dusting isn't going to be it necessarily. But if the division of labor of the couple is that one's been paying everything and the other's been taking care of the children and the household, allowing the other person to work in the leisure of not having to worry about all that other stuff, there can be a claim, and that will be judged in accordance with what you're already going to get back from the amount you'll get back from family patrimony and or partnership of bequest if that applies. For people who are not married, we have what's called unjust enrichment, which is basically the same principle, except for the fact that it's not married and burden is a bit higher to prove there. There has been, and sometimes still could be, an expense for when, for example, the example that I gave you about, excuse me, who's going to live in the house pending the proceedings. And the other one is out of the house, which means they usually have to pay someplace else, like rent or whatever, if they're not moving into the basement of their parents. We're able to ask for what's called a locket of value on the house, which either could be deducted from some future claim or whatever. It's much harder to get now than it was when it first started, so you should attach your hearts to getting that. And the important dates for when you're collecting and keeping your information are three. The values, and when you're doing a contract, be it a notarial contract for separation of property or a cohabitation contract, or even in the beginning of a partnership of bequests, because you can have a contract for that as well, is you should list both sides annexes to these documents as to what you own at the time of the marriage. At least if you put that down, 30 years down the road, you're at least going to have some reference as to what you own and the values, not just put, I owned a painting, no, put the value, whatever. Everybody agrees to that. So you have a starting point. The next important date, obviously, is the date that you got married. What was everything worth the date you got married? So you should keep any important, your RSP statement, which comes annually, your car value, whatever it is that you have, keep those papers. And the last date that's of importance is the date that you either take proceedings and or get a divorce judgment. In some cases, a judge can retroactively put the date for the valuation of assets to the date you separated, because some people separate and then they wait several years, some 10, some 20 even, to get divorced. So in the meantime, assets have been accumulating value. So you can't expect somebody who's been contributing diligently for 10 years to their RSPs since you separated to partition that amount of the RSPs. It's going to be the date that it was at the time you separated. Okay. Another interesting point, and some people think, oh, well, I don't need a marriage contract. We don't need this or that or the other thing because we both made wills. That's great. So you made wills, and in case of death, everything that you have goes to the other person. That's fantastic, except that a will can be changed daily, like your underwear. Assuming you change your underwear daily. You can handwrite a will that revokes the last one that you just did and leave everything to the little fairies of New Haven, or your girlfriend, boyfriend, or anybody else that you so fit apart from your spouse because you now hate them. So, and nobody has to tell the person who used to be the beneficiary of a will that it got changed. You'll find that out at the unfortunate time of demise. So just remember that a will isn't a panacea for all your future. I don't know if we were supposed to take a break at one point or another here.
Yeah, we can go, I just wanted to see, we do have a question, but it's actually more relevant to the second part of your presentation. I had a
Uh-huh.
quick question before we do have a break. You've talked a lot about the importance of having these agreements, be it for cohabitation or marriage, in order to protect assets. You touched on this, but maybe you could elaborate a little bit on why you need it to protect you from someone else's debt, or does it protect you from your partner's debt?
You can't in a contract or in the marriage contract stipulate, I'm never going to pay anybody's debts. Because a lot of time the debt's accumulated for the marriage of which you've been a beneficiary of. For example, a mortgage is a debt, the personal line of credit on the house, you made the renovations, you bought, I don't know, furniture on the Visa card. It's so long as it's attached to one of those assets, even if you haven't signed for it, you can be responsible for it. A judge ultimately has the last say on that matter. They could attribute a lump sum to help you pay off debts. There's all sorts of ways to work around that. But what you can do and what you should do in a cohabitation contract specifically, and you can do it in the marriage contract as well, based on what you're both earning at the time that you're drawing this up, is say, I earn 70% and he earns 30% and whatever. So you have to pay 70% of the expenses and or the debts or whatever, and so on and so forth. And again, review that, because now maybe 5 years down the road, he's earning the 70 and you're only earning, or you took time off to have children or whatever like this, and you can't afford to pay whatever debts it is. And if somebody, by the way, when I said pay attention to what you're signing, if somebody takes a line of credit and gets you to sign it and takes $100,000 out and puts it in their company and you're separate as to property, you're still on the hook for that amount of money. Bank doesn't care what it was used for. They only know they got two people on the hook. Now you can fight over it in a courtroom and maybe you'll have to pay it anyway, and maybe you won't. But if it's going into a company, you should maybe think twice about, or you should get go back to the notary and get a deed of loan. I'm loaning you this for your company. And that's a whole other thing. Anytime you're giving somebody money, I'm not talking $5, is because that would really be a lot of paperwork. You should have it documented. Okay. If your parents are actually giving you a gift, they should sign a letter, and they shouldn't say, I'm giving it to both of you, because down the road, when you don't like the person you married, you don't want to necessarily not get back the gift. So, it's for both of you, dears. It's not necessarily a question.
Okay, I have one more quick question here, and then we'll go to break.
You know what we could do, Vanessa, is not have a break right away, and I could finish, and then we can have question period.
Sure.
After the break.
How does everyone feel about that?
Unless they're dying to go to the bathroom.
Okay, hold on. Let me go back to gallery so I can see people. I don't see anyone. I don't have anybody.
As long as we get into the grandparents' access.
Okay.
All right. I'm fine with that if everyone else is fine with that.
Okay, I'm just going to touch on keeping your legal fees reasonable. First of all, they say that death, job loss, and divorce are the three biggest stressors usually in a person's life. And sometimes, unfortunately, they all collide together, and that's really bad. But so people come to get legal advice in a state of panic and emotional turmoil, and no matter what's told to them, they don't remember it. I don't know if you're hearing me, Vanessa, but you're frozen on the screen. Oh, you were just really.
I'm sorry, I was looking at something.
I thought you had frozen. You're not. You're just very calm.
Just my face.
Yes. All right. So, excuse me. It's good to always bring somebody with you that you trust and that you don't mind knowing whatever it is you're going to tell your lawyer. Open a small parenthesis. Nobody cares if anybody cheated anymore in Quebec, or much more for the rest of the country. Unless somebody was copulating in front of the children, nobody cares. Because it's basically no, as long as you've been separated, be separated that as a reason that no, because you don't need pictures or private investigation to somebody was cheating. Nobody your money for nothing. So, excuse me. So if you bring somebody who's not as emotionally involved and can take some notes for you, at least then you can go home after the meeting and you'll have heard some stuff, but if you need fine tuning on it, the other person hopefully will have taken that down and or remembered to ask a question that you might have talked with them about that you forgot to ask because you were, so upset. So also write down as much as possible your questions in advance. Don't make a 5-page summary of anything because a lawyer reading that's going to charge you their hourly rate to do it. It's better talking, but at least you can have highlights of points that you want to cover. What about the house? What about the this? What about the that? So on and so forth that you want to ask about. You should also ask when you're making an appointment about the lawyer's rate because it's usually payable as of the get-go. Most lawyers don't. I don't give free the first hour free or whatever. So you're going to end up getting a bill and you're going to go, oh, I thought it was free. I always tell people what my hourly rate is, but some people don't, and some people forget to ask. So, just like you're in a store, you're going to ask the price of that rug before you say, oh, I'm going to take it, hopefully. Be prepared. So again, having done all that homework during the marriage and before, know the values of your assets, know the dates, have some documentation about it, your last annual RSP return, your stock portfolio statement, the updated balance of the mortgage, if you have an idea of the value of the house, if you've gotten some agent, the cheapest way to do it, not always the only way you can do it, is to have various real estate agents come in and give you their estimate of what the house should be listed at. At least you have a number, which you didn't have to pay for because they're happy to do that because they're hoping to get your business. Know this, going to court is no luck. Doesn't matter what happened to your neighbor, your cousin, somebody on the TV, something that you heard, what you read in the paper. Every case has individual fact pattern that has to be dealt with. The grand lines are there, but your own experience is your own experience, and we have to deal with that. So going to court, we're going to go to court. That's lovely. It's going to cost you a lot of money, and the result is not guaranteed, and a judge doesn't know you from Adam, and they're going to take some papers and they do whatever, and some more diligent than others, let's be honest. And they're going to spew out a judgment and you may hate it because I'm supposed to get this. Well, you're not supposed to get anything. You're going to get what you get. So I always recommend mediation. They have that service at the courthouse with a judge who acts as a mediator, not as a judge. And you go with your lawyers, or you can have private mediation with a judge, a retired judge, another lawyer, or something like that. Because even most of the time, even if you don't get everything on an agreement, it can be better than a court judgment that doesn't take all the details that you want ironed out into consideration. Also, you have to remember that if you were already nervous coming to your lawyer's office, imagine what you're going to be standing in a box in front of a judge for what can be sometimes, depending on how much finances or in custody is at issue, days. You could be standing there for days and trying to remember every salient point that happened in the last 20 years. It's very difficult. It's stressful. And you have to factor that into the cost of getting a contested divorce as opposed to trying to settle. And if you do go the route of going to court, you have to remember that you can't sit in the courtroom and make faces and statements when the other side is testifying, even if it's a pack of lies. I had a client once, we had a 2-week trial, and every time he would say something, that's a lie. No, it's not the truth. Okay. But she's saying this in open court. I got a Vulcan death grip on her neck, and she still won't be quiet. And then she apologizes to the judge. Well, about the 4th time in, the judge says, don't bother apologizing because it's obvious you're not sorry. And it doesn't do anything Pre-1996, there was an article in the code that allowed people to get child support from the grandparents. That was abolished, but you're still able to have access rights to your grandchildren. I, for one, was not in favor of only giving a benefit without a cost, like in all other situations, but that's me. You have to remember that children are not a sack of potatoes, and you can't just, you're going over here on Saturday, you're going over there on Wednesday, you got soccer, skiing, piano lessons, whatever. The kids like torn, no wonder they're stressed nowadays and require pet therapy at their schools, because so grandparents, yes, have rights. The Divorce Act has strengthened the rights. If you have children for whatever reason who, and I don't know, some of the ones is maybe, I don't know what, I'm not going to even get into why I think that the child is going to try to bar a grandparent from seeing their grandchild. But you're not going to get the same time, because at the same time, the other spouse usually is fighting to get access, and they're going to prioritize a parent. Like if your daughter doesn't want you to see the grandchildren, meanwhile, her ex-husband to be is trying to get access to the kids, you're going to be like down the line and what's left over. Because usually courts believe that you're going to see your grandchildren while they're with your own child. Otherwise, the only option is to go to court. You have to explain why. If obviously if the child is, under one, they haven't had time. They may know you by smell or something, but it's not like you've had time to form a really big bond before a fight starts, as opposed to if all of a sudden at age 12, the parent wants to forbid you from seeing your grandchild. Age 12, 13, 14, the child could actually either be subject of psychological evaluation to see how they want to be or not with the grandparents. It's a very difficult situation. It's based on your own certain facts, and it's tragic, but it happens. I don't have a lot to say on grandparents. I know it might be prime for the people out there, but it's such a delicate and difficult arena to be in. I've been involved in cases, and
So what would you recommend if someone is in a situation?
well, I told you what I'm going to recommend. Nobody's going to like my answer, but if you have children who, all of a sudden or from a long time hate you for some reason and are terrible and won't let you see your grandchildren or whatever, either get a dog or adopt be a mentor to somebody else's kid who's been left behind by the system in foster care or something like this, because, you're never going to, the whole thing is going to sour the entire thing for the rest of your lives. And again, tragic. I don't know what to tell you really, because I don't know what I would do if I had to face that situation, but I think it's even more gut wrenching than the parties that are fighting inside of the divorce over the children. But again,
and there's a question here.
The only person that's going to suffer in the end, the real suffering, will be the kid who's being split in 3 or 4 or 5. God forbid you have reblended families on all fronts. I mean,
it gets messy. Yeah. There's a question here about if a grandmother is estranged from her own daughter, does she still have visiting rights to see the grandchild? It's not a divorce situation. They're just not speaking.
Yes, you can take a proceeding based on the civil code to have visiting rights. But if your daughter or son, whoever it is not going to agree, you're going to end up in a courtroom and you got to take an action. It's going to cost money and it's going to cause stress and all sorts of things. So, and meanwhile, you can assume, I would anyway, that whichever child you're having a fight with about this is going to be trying to also poison your grandchildren against you. Parental alienation, but this is grandparental alienation. So you have to ask yourself, is it worth it to your grandchild for you to do this fight? Or sometimes what might be helpful is if your own child is denying you access, align yourself with the other spouse. because that person's going to probably also get access, and then maybe you can visit the grandchild through that. May seem odd, but that's a way to go.
Is there family mediation available through the court system to help families avoid going to court, or?
There's definitely mediation available for people who have instituted actions and have children to go through the court. That system is, as I said, free with a judge. There's regular mediation with mediators. There's a whole order of mediators that you can contact. There's private mediation because the regular government mediation is about 6 sessions that you have for free, and other than that, you pay a tariff, whatever the tariff of the mediator is. And private ones I've done with retired judges or former lawyers, sometimes from the Court of Appeal, who have retired, and they take on the case. You're going to be paying money for it, but it can help resolve issues like that. And sometimes, unfortunately, no matter what, just like people are getting separated and divorced in the primary relationship, no matter what you do, no matter what court order you get, it's going to be worth nothing as far as access is to children. Because if somebody really wants to frustrate your rights or make things a living nightmare or whatever, there's no piece of paper that's going to make them change who they are. And then you should ask yourself, and don't hate me for saying this, but you have to ask yourself, what an honest question to yourself, what did you do for your child to do this to you, to forbid you or curtail your access to your grandchildren? Because there's a reason. And if it's a really bad reason, maybe you need to think about what you're doing before you try to take a proceeding.
There's a question here.
Keep those questions coming.
Yeah, another one. This is a little bit particular. Well, it's interesting though. If your loved one, your daughter or son, as you said, this is applicable to both, is living with an immigrant and they don't want to marry, what are your rights to access the grandchild if they are brought back to that person's home country? In this case, it's Algeria. But if there's no marriage and the grandchildren are taken to another country.
Are we saying that the couple who had the child are both going to Algeria? Or just the person from Algeria who was the immigrant is taking the child to Algeria for whatever reason, holiday or
Can you have
kidnapping?
access to grandchild here? And if they go to Algeria, or her goes with the grandchild? It isn't clear.
Okay, well, first of all, let me focus my ideas here. If I was the other spouse partner of the person from Algeria, I wouldn't let my child go to Algeria without a great deal of terms and conditions and court orders. That said, trying to get your court order acknowledged in Algeria is a whole other kettle of fish. So you need to, and I was involved in a case 15, 20 years ago where the couple, he was Egyptian and she was from French Quebecer, living in California. And for whatever reason, she decided she no longer wanted to be married to him. And one day up and took the kids and came to Quebec. And the Hague Convention was put in place because in a sense, it's a kidnapping. Originally, poor Quebec mother, French newspapers, whatever. And her argument was, well, he's Egyptian, he's going to kidnap the kids, which is why he shouldn't have access. And my answer to that is, what, you married and living with him with a bag over his head? You didn't realize he was Egyptian at the time you got together and you decided to have children with this person? Ultimately, unfortunately, it was a very sad tale that he got to have custody actually in the end, but unfortunately both parents subsequently died. So all that fighting, not so great for the kids, for the time that was wasted and the money that was spent. Trying to get any judgment, I mean, it's not like you're going to England or the United States or something where some of the legal system is somewhat, but you're still going to have any foreign judgment there to here, here to there, has to be homologated by the court system in place, whatever country the children went to. If they're taken illegally, then there's the Hague Convention you go to, but that's usually for the parents, not for grandparents. So, unless you get a contract has been put in place, an agreement of some sort that, the person's put up, for example, unless you're dealing with millionaires, put up $50,000, $100,000 to guarantee the safe return of the child back, I'd fight tooth and nail for that child to leave Canada.
Yeah. Here's a good question.
After the milk is spilled, it's really hard. Better yet, after the toothpaste is out of the tube, very hard to put it back.
Yeah. Some families may not have the funds to engage a lawyer to go through the courts and maybe dealing with this kind of case. What kind of legal aid, if any, is available?
Well, legal aid is available for everything that I just talked about, except you have to qualify for legal aid. So if you're sitting on a $500,000 house, chances are you're not going to qualify. If you're earning $10,000 a year and have no property in your name, you qualify, but you have to go to the legal aid clinic in your area and find out if you're qualified. Other than that, unfortunately, the system is rigged for the rich and the extremely poor, and the people in the middle are screwed. Yeah. Which is why you need to save your money at the get-go when you're getting married so that you can access. Oh, by the way, put it in a safety deposit box in a bank you don't normally deal with. Because, these things are find outable, but at least you will have access should you need it in an emergency. And you're not, some people don't leave their relationships because they feel that they have no place to go, no resources to count on, whatever like this. The only reason that they're in that situation is because they allowed themselves to become that situation, because they didn't follow all the advice that I told you at the beginning of this conference, which is know what's ever going on. Talk about it before, talk about it again, keep talking about it, and make sure you know what's happening with the money.
Yeah.
And if you're putting money into, you're paying the hydro bills and the bell bills and whatever, all the expendable stuff, and the other person's building assets and separate to property, and they're putting their assets in the stock market, which is not necessary, it's not a family patrimony asset, you're not entitled to that either. So that person's going to have the resources and you're not. So make sure you put money aside. In an airplane, they come on the loudspeaker at the beginning and they say, before you help anybody else, help yourself and put the mask on your own face. That's exactly what you have to do in a marriage if you want to avoid a divorce or really bad surprises down the road. I'm sorry to be so blunt, but I'm known for being blunt. It frustrates me how many times I say certain things and people are like, they look at me like deer's caught in the headlights. Unfortunately, when they come to me, by the time they come to me for the divorce, I can only deal with what actually happened, not what should have happened in order to prevent some of this stuff. I have done marriage contracts for, extremely wealthy couples, because even though they loved each other and they both have finances, they wanted to know, they wanted to have at least the ground lines of what's going to happen should the terrible thing happen and they get
go wrong. Yeah. Here's a question
and you have to
RSPs.
assume, sorry, you have to assume it's going to go wrong. I don't care how much love everybody, you have to assume it's going to go wrong. My oldest married couple that came from me divorced were married for 50 years. So when people say, I don't need a lawyer, I'm not going to get divorced. I said, yeah, well, maybe I now can't wait because I'm a certain age, but a lawyer is going to be out there and somebody's going to get divorced. Being married for 50 years is no guarantee to anything. So what I was going to end my speech with was, you're born alone and you die alone, especially with COVID. And in the middle, you have to take care of yourself. And then you can take care of other people. And taking care of yourself is finances. That empowers people.
I think that's really important. And I think it's important for a lot of women to hear, because we tend to not,
you abdicate and gloss over.
Yeah. Yeah. We hand it over. As you said, we're in love. So you'll
you're
take care
busy
of
taking care of the kids and the soccer and the doctor and the dentist and the piano lessons and doing the homework and whatever, and have no idea what's going on with the money. And there are men that are like this too. Believe me, there are husbands that have abdicated all this stuff to the wife. you're just causing the conditions for terrible outcome.
Yeah, no, you need to protect yourself for sure. Okay, question here on RRSPs. Can we still apply 50% of our married partner's RRSPs in the case of a divorce, and what is the timeline?
I'm not sure what you mean by apply. RSPs are part of the family patrimony and will be divided 50-50, subject to the portions that either party might have had pre-marriage. Because the amount of money you had pre-marriage, there's a calculation that will have to be made. So again, and as I said, at the time of the divorce proceeding, at the time of the marriage, have the paperwork in some folder ready should you need it. And by the way, don't keep that folder in your house. Stuff disappears. So you have a best friend, you have a parent, whatever, lock it up, make it secure, but put it somewhere else. I've had people, I got all the stuff, I put it in the car, and then he took the briefcase out of the car. Good for you. Try to find it afterwards. So the RSPs, if you had $10,000 before, and it's 30 years later, that $10,000 accumulated presumably an increase in value. So the increase in value and that amount of the RSP is yours. It's not in the family partition, but you have to make the proof about, how much you had before and the value. The rest, if you contributed during the marriage, is divisible in half.
Okay.
Now, if you inherited RSPs from some relative, because they had RSPs and Aunt Matilda again left you her portfolio of RSP money that she'd accumulated, usually it's going to be liquidated and given to you. But if it comes over on that, sir, as we say, that shouldn't fall in either. But anything else, it's divisible 50-50.
Okay. Oh, someone's asking here, what is the RRSP? So that's a registered retirement savings plan that we have here in Canada. I encourage you to learn about it. It's important, putting aside for when you're retiring.
And there's pension plans also with companies, let's say big ones like Air Canada, Bell Canada, all those things. And they're subject to varying rules and have to be either you agree on an amount of money, but the statements that you might see from your spouse as to what the value is every December the 31st is not necessarily the entire value of the RSP. It has to be actualized, because if some company is going to pay your spouse on retirement in that statement $85,000 a year, the value of the plan is not $85,000, because in order to pay somebody $85,000, it's got to be like $1 million sitting in the company to generate that income. Now that's the value that you need. And sometimes you have to engage an actuary to do the calculation. And it's not 50-50 necessarily, because actuaries take into account the age of the people and how long you're going to live and yada, yada, yada. But it's usually bus drivers. It's a huge number usually if you're getting those kind of annual annuities from them, and you want to know the other number. So just because somebody, and if somebody tries to, rush here and I'll give you, $42,500, it's because they know what the number is on the other side. So don't be in a rush. You make mistakes that way and you will repent for the rest of your life. Get the information, know the information, make sure the information is exact. Somebody that tells somebody, I'm not going to pay you a dime and you'll get nothing and be on the street is a liar. Plain and simple.
There you go. Anybody else have any questions they want to send through the chat? You can put it in the chat box and I will read them out. You can either send it to me directly or to everyone. There's so many questions I have, but I feel like, as you said, we would be here for, I don't know how many hours. There's
Go ahead if somebody else isn't right. You guys are too shy. That's, nobody cares what you're writing. If you have a question, nobody's going to judge you about it. No question too stupid to ask.
No, exactly. I agree. Like if there's terms being used that you don't know what the person who asked about the RSP, then, please go ahead and ask.
Think about it this way. Nobody on the planet with 8 billion plus, the only experience is only theirs. It's only your thing. you could be asking a question, you'd be helping somebody else who's listening.
Yeah.
They'll
Yeah.
give the answer.
So here's a question. Somebody would like to know how it works for payments and or investments made from a joint account.
Well, the premise of a joint account is that everything is 50-50, even though some person might be putting in, more money than the other one. Investments from a joint account, if you mean money was taken by one from the joint account and put in their sole name or whatever, again, it's going to depend on your matrimonial regime as to how it's governed. And or if you can trace it, if that's going to happen and calculated, you could try to make a claim back, because if you can't have a partition of the stock portfolio, for example, that was used from the joint account or the line of credit for that matter, for one person's benefit only, you can try to make the claim to get your, share. In a case of somebody, unmarried people who have a joint account and one of them took the money and invested it in, I don't know, business, stocks, whatever like this, that's unjustified enrichment, unless you had an agreement with the person, because you're giving money to the other person to benefit only themselves.
Oh, that's good to
You
know.
have to be able to prove it.
Yeah.
Everything in court has to be able to be proved. It's not just, I think he took this, or I think she did that.
Here's another one, is what you have in the stock market in the RRSP also going to be in a 50-50 split?
If your RSP is invested, a portion of it in stocks, yes, ultimately it's the number of in the RSP
It's the
portfolio
total amount,
itself,
right.
which has been deductible because you deducted on your income tax, regardless of what it's holding. So, because that amount is part of the value of the entire RSP, because you could have a part of it in stocks, you could have part of it in a bank account, you can have a part of it in I don't know what, but it's the number of in the RSP. And there can be more than one. People have been known to have more than one RSP. They start a plan when they were 20, and they got another plan with another broker of some sort, financial planner, and they have another number. You got to know them all the more reason to keep talking to each other.
So, what happens? I mean, this is an extreme situation, but as you said, actually, maybe
They're
it
all
isn't. Maybe this
extreme.
happens more than I would think. But I know of someone who separated from their partner and found out that they had taken out a second mortgage on the house. That now don't ask me, I'm not sure if she had signed on.
You could not possibly take a second mortgage out on a house unless the house was solely in the name of that person.
Maybe. And so in which case would she be, I guess it goes back to the question of how much of another person's debts are you responsible for in the case of a divorce? If your name's not on the mortgage.
Well, if your name's not on the house, first of all, you're not going to know about maybe some collateral. Some diligent bank people or notaries are going to get the spouse. We have to have that signature, in which case you're not going to put your name on it unless you know where the hell the money's going. Because the house, nonetheless, let's say it was bought, you got married on December the 1st, bought the house on December the 1st, but only in one person's name. That house falls in family patrimony, and anything attached to it comes off, any debts, unless, as I said, money was taken from even the mortgage or the line of credit and used for some other purpose than a family asset.
Okay.
Like businesses or stock portfolios or whatever.
Or gambling addiction, for example.
Well, that's even worse, because at least with the stock portfolios and the other thing, there's an asset that you can find.
Yeah.
Gambling, the casino owns that asset now, and try to find that back out. But somebody with a gambling addiction, that is a reason to ask for unequal partition of items.
If you end up in court, you mean?
Yeah, or even in a settlement, because if the
Right.
person squandered $100,000 of the value of the house by taking out a mortgage, which maybe you signed for because you thought it was going to be for some other type of financing, didn't
Right.
know the person took it out then and went gambling, you're going to say gambled away $100,000, of which I should have at least 50, or whatever it's worth after the fact. And so I don't want to give up a 50-50 split of the house. I want to give up, 40-60 or whatever the equivalent value is, commensurate with the money that was absconded with for bad purposes.
Yeah. Okay, here's one. How does it work when it comes to personal family loans? I assume to one individual, but
Well, family loans from a parent to the child, is that what we're talking? Family loans? Somebody loaned one of them or both of them money? I need
yes.
more of a, yes. So again, if it's actually a loan, it should be in writing. Doesn't have to be a form. Formal is good. Formal is better, but it can also be on a piece of paper, but make sure everybody has a copy of it. Because if there's only one of them, make a few originals, just like we make a few original consent, one for the court, one for the husband, one for the wife, one for the lawyer. I have 5 copies of an original that I have. So each lawyer, assuming there's 2 lawyers, have copies also. So somebody's going to have a copy somewhere, so you can use it. And if in fact it is truly a loan, and it should provide also, if it's a loan, should provide something of either regular return payments and then an interest rate, and how depends on what your true objective is to getting the money back. But if you gave somebody $25,000 to put us down deposit on the house, and let's say the parents of the husband gave this money, and they, even if it says a loan, if there's like absolutely, and 30 years later, there's not been one payment back, no interest accumulated, nothing, could be deemed as a gift or disguised inheritance, although the loaners have not died yet, So it all depends on the strategy you're trying to accomplish, how things
Right.
need to be set down.
Oh, here's an interesting one. What happens if an unmarried couple who live together, have children with no wills or contract, both die? What can the grandparents do to try and obtain custody of the children? Or do they have rights to custody?
Both parents died?
Yeah,
Oh,
no
that's
wills.
terrible. No, well, so you can't, first of all, you can't will your children. They're not, a sack of potatoes, as I said before. They're living, breathing people. And usually there's maybe some periphery of relatives out there on both sides that would have to take a family council and decide. And if that's not possible, the grandparents can apply it under the circumstances for custody. You might get a counter suit from the other set of grandparents, who knows? Or
Yeah.
brothers or sisters, everybody can fight, and ask, but certainly you have a right. If you've been estranged for 10 years, it's not going to be as good as, the daughter's sister's been taking care of the kids after school for the last 5 years, so it's going to up. Every judgment involving a child is based on their best interests, not yours, not somebody else's, not the parents, not the relative, the child. I hope
Yeah.
that answers the question, but you do have a rights question of whether you can exercise it or not.
Yeah, you have the right to apply, and then it falls
Yeah.
to the powers that be. I don't know.
And
if you can
sometimes
answer
it can be
this.
settled amicably through a family council and figured out what you're going to do.
We're back to, I don't know if you can answer this, but I'm going to ask it anyways. Is there a way to break the hold of the wonderful Algerian on the daughter to protect her and the children?
Well, the hold, you mean she's what's
know.
the word
I
I'm
think she
looking
means-
for?
I think they mean
Psycho-
that their daughter is bewitched or
Bewitched.
bedazzled. Yeah.
Bewitched,
Hopelessly in love,
bedazzled,
they're
yeah.
concerned. Yeah.
Yeah, well, concern, start inquiring now as to a team of mercenaries and go back to Algeria and kidnap the kid back. So start saving your money, because that's gonna happen. And if she's over 18, I assume, and there's not a lot, you can't take an action to prevent her from listening to her husband.
Yeah, I think it's sort of limited.
Sadly, she could be under the spell. Some people try to ostracize the spouse or the partner from all friends and relatives in order to have control, whatever like this. But unfortunately, until that person wants help,
There's not much you can do. Yeah.
Like
Okay,
an
we're gonna do
ele-
one last one. someone has asked if you could speak a little bit about family councils. They were part of one for a nephew who was a minor who inherited a sum of money when his dad passed away.
Okay, I'll be honest, I don't deal with family councils myself. I'm not an expert in that subject. Maybe another subject topic conversation. All I know is that if the both parents have died, or if one's been, let's say, maybe judged incompetent, put in a mental institution, somebody needs to have, even if it's just one of the two parents that died, there can be a family council. I had a friend who spent a lot of years in a courtroom fighting over the money that her mother left her niece because the father was fighting about it. So, but I'm no expert in that, so I really can't. I'm not going to, start guessing here as to what could happen.
Okay. There's one very case-specific question. I think what I'll do, Linda, is instead of asking this publicly, because there's a whole background and story to it, maybe I can email it to you. So to the person who's passed this question along about the person who passed away from cancer, it's a very sad story. I think we'll not tackle that because it's quite a specific legal question, and I don't know. Okay, I can probably do broad strokes here, though.
I'll try.
Yeah, I'll try. So this person's loved one.
Or Vanessa, do you want to have a 5-minute break for those who need to go to the toilet? You can read it and summarize.
Well, we're
it.
going to actually wrap it up soon. We're supposed to be finishing soon. So
okay. All right. So go ahead.
Okay. So somebody's daughter passed away.
Mm-hmm.
And the living parent, the living father, wanted to deny access to the grandmother.
Okay.
She went to court to see the grandson, was granted 1 day a week and 1 weekend a month.
Mm-hmm.
Next year, the child will be going to school. Is it worth it, or can she request to see him more often than once a month by going back to court?
Is it worth it? Only that grandparent can decide if it's worth the mental and financial stress to go back to court. And again, you never know what's going to happen. What you might want to try to do is see if the other person wants to participate in mediation to see about, strengthening. And I don't know how is the age of the child mentioned in there somewhere?
No, I mean, I assume if they're starting next year, he will be going to school. So I'm assuming they're young, like maybe 5 or
6.
Yeah, little.
All right. Well, assuming that the person has been, not missing any of the court ordered time that they already got, school, I'm wondering why, now that the child is going to have more stuff to do, would they need to have more time? Maybe they could try for holiday time, summertime. I don't know if any of that got adjudicated in whatever judgment that was received. But it's not that grade 1 should be that stressful for a kid. It depends on also all the other activities. Like I said before, for even between parents that are separating, there's only so much of a kid there is.
Yeah. And as you say, every case is quite unique.
And is the relationship still hostile? Has it mellowed any? There's way too many factors to be able to address that question adequately.
Yeah. I mean, I think, as you said, you can always go back to court, but you have to think about what it's.
Certainly, as the child gets older, it could be also easier to have, I don't know if the weekend is a Saturday, Sunday, a Friday to Sunday. You could ask for ped days that are attached to any particular weekend, extra holidays, hot time in the summer, yada, yada, yada.
Yeah. Yeah. Okay, well, I think we're gonna wrap it up because it is our time. Thank you so much for this. I feel like each one of those topics, we could have an entire other webinar on many of them. And yeah, I think reiterating that how important it is to educate yourself and protect yourself when it comes to your finances and your assets. Even if you think you don't have a lot, it's almost more important because you don't want to lose that little that you have.
Yeah,
put
every
together.
dollar
I mean,
counts at that point in time.
yeah.
I mean, I had a client back at the beginning of my practice who they were married and she was a bit abused mentally for sure. And all she wanted to do was be divorced and she didn't want anything. And I used to keep a baseball bat in my office. And I said, I'm going to take this bat and bat you over the head because you're not walking out of this marriage with nothing. Anyway, we ended up, I think at the time, whatever the assets were, she ended up with something like $35,000, which was $35,000 more than what she wanted to just walk away. It's the same file in which we spent 2 hours, 2 lawyers fighting over a plastic Christmas tree, but that's a whole other episode. You know, imagine the cost of that plastic. You could buy a forest, for God's sakes.
No, but
Anyway.
I think it's really important. People in difficult emotional situations just want to get out, and they don't necessarily always value themselves if they're coming out of a difficult relationship. You have worth, you should protect yourself, walk away with something so you start over okay. I mean, these are difficult times. And yeah, a bad divorce, you just want to get out. Of course you do.
Yeah, you want to get out, but you rush out and you repent in leisure. In any event, end of the story is that every year after that, she sent me a Christmas card until the day she died, you know, thanking me. And then her son, as it turned out, is a small world, was a FedEx driver that turned out to come to our office with packages on occasion, and he thanked me for his mother. So, you know, those are the ones that I feel most happy about, that was able to make some difference for the future for somebody that needed it, as opposed to, you know, millionaires fighting over millions.
Yeah, I mean, those, yeah. Anyways, thank you, Lisa. There's a bunch of thank yous. Sorry, go ahead, Yvonne.
I was just going to say, my advice to the grandmother who is wanting more time is to make sure the time she has, she leaves a lot of memorable memories for this child. And this child eventually grows up and comes back to the grandmother. So has such pleasant memories of the time spent that
together. Yeah, I know, as children.
I agree with that, and I would add.
Yeah,
I would add and videotape these good times, because when you want to go back,
yes,
to get maybe more time, you'll have video proof of the good relationship that the child has. Try to have somebody else do the videotaping and make it look natural. It's not like you're force feeding the child to have a happy time. And the same can be applied to parents who have custody, who are fighting over it, because ultimately, in a lot of cases, while one parent is fighting to keep the other parent away, at a certain age, the child makes the determination. They want to be, boys sometimes want to be with their fathers, girls want to be with their mothers, whatever, like this. And they were fighting all over it. Anybody that's fighting over this stuff, I know that some people have to fight over this stuff, but anybody that's doing it, they're just wasting time and money, because ultimately something's going to shake out and in the way it's supposed to. And if it doesn't, well, you know, again, no piece of paper judgment is going to fix that, sadly.
So thank you so much for this, Linda. I really appreciate it. There's a lot there, and I think there's some really important things for people to think about. I know I'm going to check my house insurance, and I'm going to make sure my name is on it.
Check all your paperwork, check all your investments, check your everybody. If you don't have it,
please,
or review it, get a will, make a will properly.
Take away, go. So thank you so much, everyone. Linda, that was excellent.
Sorry,
that was
Vanessa.
Yeah.
Vanessa. And life insurance policies.
Yeah.
That should be checked out too. What kind you have, who you're leaving it to, you're getting divorced. You might want to take the name of the husband off and put the name of your children or an estate or something else. You got to check all this stuff all the time. People evolve. So should the paperwork.
Yeah, there you go. That's something you should have tattooed. People evolve.
No, I'm not a big tattoo fan.
So thank you, everybody, for attending to answer the questions. Yes, this has been recorded. We will share it. And Linda, thank you again. I hope to be doing another webinar with you soon. Everyone have a good day.
Excellent.
If you think of anything that you want to follow up on, you can email us at info@seniorsactionquebec.ca, and we can always pass it along to see if Linda can help.
Fantastic.
Thanks, everybody.
Thank you.
Thank you.
Have a good day.
Bye-bye.
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 Thanks, Linda.
Oh, it's my pleasure, Ruth.
We'll
That
talk
was fun.
soon.
It was fun. Thanks.
Thanks
Bye-bye.
again.
Bye.
Bye-bye.
Bye.